Good Monday morning. Welcome to meeting 127 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in a hybrid format pursuant to standing orders. Pursuant to the order of reference of February 7, 2024, the committee is commencing consideration of Bill C-352, an act to amend the Competition Act and the Competition Tribunal Act. We have Mr. Jagmeet Singh with us today. Thank you for being here to present your bill. Before I begin, I would like to remind all members and other meeting participants in the room of the following important preventative measures to prevent. This is because of the health and safety for everyone, and especially that of our interpreters. So, without further ado, I'll give you the floor, Mr. Singh, for your opening remarks. Thank you, Mr. Chairman. Please give me a moment to start my stopwatch so I can. I'm so pleased to be here. Thank you for this opportunity I have to present my thoughts on my bill.
Topic that a lot of Canadians think is relevant in their lives, but I believe this is fundamentally important for Canadians, and I think of two examples why this is such an important bill: food and cell phone and internet fees. When we talk about food in our country right now, we're up against a really serious situation where, as you know, Mr. Chair, Canadians are faced with record food bank usage. 1 out of 4 Canadians are skipping meals because the cost of food is so expensive. And Canadians know when they go into a grocery store and they're paying the highest fees ever for their groceries. On the other end of that, they've got corporate CEOs that are making record profits for their corporations, and they're being gouged and ripped off. That has to stop. And we know this is not something that Canadians are unfamiliar with. Back in 2018, the large corporate grocery stores and bread producers worked together to rip off Canadians with the bread price fixing scheme. And we know that the cost of that was significant. Canadians were ripped off to the tune of $5 billion. But the biggest fine that was levied for one of the major players of this bread price fixing scheme, Canada Bread Company, got a fine of $50 million. In the scheme of things, when the collective benefit that they accrued was $5 billion that they ripped off Canadians, a $50 million fine is a slap on the wrist. So that has to stop. We know that protecting consumers and fighting back against corporate greed will lower the cost of food and cost of living for Canadians. The other area where we know that this is significant is when it comes to cell phone and internet fees. We pay amongst the highest cell phone fees and internet fees in the world. And it's no surprise, as a result of merger after merger, there is a massive concentration. Just 3 cell phone and internet providers make up the majority of cell phone and internet services in our country: Rogers, Bell, and TELUS. And so we saw recently a merger which only makes things worse. The merger between Rogers and Shaw is only going to mean higher costs for consumers and less options. Again, this is going to make life more unaffordable. Another example of corporate greed. That merger should never have happened. And my bill would allow for measures to ensure that that doesn't happen in the future, or makes it a lot more difficult. We know that the cost of living is up, and we know that corporate greed is driving it up. And my bill hopes to prevent that from continuing. Stopping large corporations from ripping off consumers will lower prices for Canadians. I believe that the role of government is to strengthen and protect consumers' rights, protect consumers against exploitation, and that's what I hope to do in my bill. So I want to break down some specifics to lay the foundation for, hopefully, your questions. Since the introduction of my bill, we've been able to force the government to make significant changes to their existing bills to protect consumers. So I want to go over those changes that have been made. So these are changes to C-56 and C-59. New Democrats put forward amendments specifically to increase penalties for anti-competitive behavior and to make it easier for the Competition Bureau to go after these large corporations when they rip off Canadians. We also specifically changed definitions to include price gouging as an offense. We also ensure that the Competition Bureau is able to initiate investigations so they can actually identify when problems are happening, compel documents, and go after corporate greed. There have been changes now because of what we forced the government to do that would make it harder for mergers such as the Rogers-Shaw merger. But there are 3 things that are outstanding, or fundamentally 2 main areas. One is the bread price fixing that I spoke about. That remains something that is not covered in the way that it should be by the Liberal government. They've refused to put in place strengthened penalties. If corporations are doing the crime, then they have to pay the fine. And what we want to see happen is, in the cases of large corporations working together to rip off Canadians, there should be severe and significant fines. And that's something that's missing in this bill. And we think that there should be certain mergers, if they hurt Canadians, they should be banned outright. Not an assessment of whether this will hurt or not hurt, or whether they should go ahead or not. But if they reach a certain level, they should be banned outright. And that's a change that this government was unwilling to do. I would point out that I believe the government can be a force for good for Canadians. It can fight corporate greed and make life affordable. For decades, the Liberals and Conservatives have ignored corporate greed, purposely ignored strengthening the rights of consumers, and ignored the tools that the Competition Bureau needs to take on corporate greed. I hope to change that with this bill. We have done some significant changes with amendments. This will finish the job.
Thank you very much, Mr. Singh. And to start the discussion, I'll turn it over to MP Williams for 6 minutes.
Thank you very much, Mr. Chair. Mr. Singh, you claim you're working for the fairness of people and Canadians, and you're here today to claim that you're standing up for competition. After your agreement with the Liberal government that's now been over 2.5 years, there's been 3 mergers that have gone through. RBC purchased HSBC, Canada's #1 bank, buying #7 bank. Rogers bought Shaw, and WestJet bought Sunwing. And this has been detrimental to Canadians. Canadians are hurting right now. Why did you not stand up for Canadians and say no to these mergers?
That's not all the case. We did absolutely say no to those mergers. We said it was wrong at the time. And not just saying that it's wrong, now I'm putting forward a bill that would prevent those things from happening. We actually put forward the amendments in the other bills that I noted to make it harder for these type of mergers to happen. We've been very vocal opposing mergers that hurt Canadians. I've asked questions in Parliament on these very matters. And we are now I'm putting forward a bill in my name that specifically would ban mergers that make up more than 60% of market share.
So, Mr.
And in
Singh,
addition, we've put amendments that make it harder for mergers that are 30% and above.
So, Mr. Singh, you do have an agreement with the government. So at any time you could have ended that agreement. You could have included this as a stipulation in the agreement. And I think at the end of the day, we look at these agreements as useless because in not standing up for Canadians, these corporations have actually gotten bigger. When we look at HSBC and HSBC and RBC buying HSBC, even in Vancouver, where you reside, HSBC had 10% of the book for mortgages. After that merger, interest rates went up almost 1%. More importantly, profits went up. Can you tell me, Mr. Singh, in this last quarter ending March 31st, what was the increase of RBC's profit versus the last quarter of December 2023? Just a number.
We are absolutely opposed to the type of mergers, and that's why we're putting forward a bill to do exactly that. So if the Conservatives are in support of these type of changes, I would invite them to support my bill, which would ban outright any merger that increases the market share beyond 60%. Support the bill. The bill is about ending these type of mergers, stopping mergers that hurt Canadians.
So, Mr. Singh,
for a long time, Conservatives and Liberals have ignored this problem.
The number is $1 billion. That's how much more profit RBC made in the first quarter of 2024 versus the last quarter of 2023. HSBC only made $300 million in that last quarter. So you can see what happens when mergers go through. Not standing up for Canadians means that Canadians are hurting. When we look at cell phone bills, and you've mentioned cell phone bills, Canadians do pay the highest cell phone bills in the world, and yet you stood up again and didn't say no to the Rogers-Shaw merger.
That's not true.
And at the end of the day, you could have ended this merger. You could have stood up to the government and said, this is our red line. We're not going to do this. And what's happened since then is that Rogers and Shaw both benefited. But maybe you can tell me, Mr. Singh, how much more, and I'm going to start with this. The Prime Minister that you support said in the House of Commons that cell phone bills went down by half. He said that. He said cell phone bills are down by half. So I'm going to ask you just a simple question. How much more in the year ending, March 31st, 2023, did Rogers make, and this is wireless revenue per user, than the year prior? Just the number.
We firmly oppose the Rogers-Shaw merger. I asked questions in question period directly to the ministers and to the government. I've been on the record. I don't know if the member ever asked a question on this ever. I've asked questions on this directly to the Prime Minister, said it's wrong. And I'm putting forward a bill that we're discussing right now that would protect consumers against these type of mergers. I'm literally addressing this matter in a law that we are talking about right now.
And Mr.
So
Singh,
if the Conservatives are interested in, which is news to me, protecting consumers, then they could support my bill, which would ban mergers that increase market share beyond 60%.
And Mr. Singh,
I oppose mergers that hurt
Mr. Singh,
Canadians.
you're talking
and
to-
we've got bills right now, a bill in front of this committee that would exactly do that, protect
and
consumers
Mr. Singh,
against
you're
mergers.
talking to the competition critic, the shadow minister for the Conservative Party, because our leader decided competition was that important to put someone in this position. And when we talk about where you could have been, you're actually in another position. You could have stopped the government from approving these 3 mergers which have hurt Canadians. We say, it's a walking contradiction. You're standing up for these corporations who have only got bigger
I'm not
since
standing
you've
up for
been in
them.
power,
I'm
and
opposing them.
consumers have lost less power. We're not seeing the prices come down. We're not seeing competition in. And you presented a bill, and we presented lots of changes. Even you and I had the both efficiency defense change that this government stole from us. That was there, but you're not standing up for Canadians, and Canadians feel that you've sold them out. They feel
That's
that
not at all
you're
the
not
case.
standing up to the corporations. They feel that they're not going to do it.
That's
So
not at all the
people
case,
only
sir.
trust actions match word. Mr. Singh, the other push that we're pushing for in Canada is open banking. If we want to talk about taking a chunk out of the banks in Canada, open banking would do that. In the UK, when open banking was implemented, it saved the average person in the UK $400 a year. There's no transactional fees, no monthly fees, no overdraft fees with open banking, and it's only with 14% market share. And this government has 6 years to bring legislation to this government. They picked a regulator and only gave them a pittance, $1 million, to get the regulations in. This regulator, FCAC, was just in front of a Senate committee. Do you know how many of the 27,000 complaints that they answered since 2019? Can you just tell me the number?
So it's interesting. I mean, I'm literally saying to the member that we are opposed to large corporations ripping off Canadians. I have opposed the mergers. The member knows that very well, knows that I've stood up and opposed it. I don't know if the member himself has ever asked a question on this in question period, but I have. And I can say further that I noticed that the member has not asked a single question about the corporate greed in grocery stores. Is it because that your leader has been a receiver of the max donation from the CEO of Metros? Is it because the corporate or the conservative strategist for the party is a lobbyist for Loblaws? Maybe that's why they're not willing to talk about corporate food in corporate grocery stores, but I am. I'm ready to take them on. I'm ready to take on all corporations when it comes to ripping off Canadians.
Thank you, Mr. Singh and Mr. Williams. Je passerai maintenant la parole à Monsieur Turnbull pour 6 minutes.
Thanks, Chair, and thanks to Mr. Singh for being here today. It's kind of ironic hearing the Conservatives talk about saving $400 per year when they won't support saving families money on child care, dental care, pharmacare, or feeding hungry kids, or a Canada Disability Benefit, or I mean, the list goes on, the Canada Child Benefit, and many more. It's, and directed to you, Mr. Singh, I know that you are saying that you forced us to do certain things. Obviously, we'll have to disagree on that because the Government of Canada has put forward multiple rounds of revisions to the Competition Act, C-19, C-56, and C-59. And I think the collaborative efforts of working together with the NDP on some of those changes has been very productive. And I think that we should all take that approach when doing our parliamentary work, because really what we're here for is to serve Canadians. We know competition in the market. More competition means more options, means better prices. We've been saying that since day one. So I think, we may beg to differ on some aspects, but I think that's sort of where the government standpoint comes from. Mr. Singh, I wanted to take a step back. So I'm interested in your approach to competition reform. And I know that you're a former defense attorney and a defender of the Charter of Rights and Freedoms. Would you say that you appreciate the principles of natural justice that are protected under the Charter?
I think I know where the member is going with this line of questioning. As a lawyer, I can tell you that what we've found is that giving judges pure discretion when it comes to setting sentences has resulted in the case that I gave you, the $5 billion that large corporations ripped off Canadians with bread pricing. The biggest fine that a judge levied in that case was $50 million, which is a slap on the wrist if you think about $5 billion in net revenue. What I'm hoping to do is establish some guidelines for judges. Judges follow guidelines. They're going to follow jurisprudence. The highest fine was $50 million. That's not going to be significant to deter. So what we've said is that the judge should be able to use deterrence to the extent of 10% of the revenue of a company. So in the case of Loblaws, $60 billion revenue, they should be able to impose a fine of $6 billion. $6 billion is deterrence. Without having guidelines, judges won't go further than jurisprudence. And right now, $50 million is the highest fine that's ever been levied. It's far too low.
But you agree that that judge, jury, and executioner shouldn't be the concentration of power in any given commissioner, right? I mean, do you not agree that in some cases we need a clear separation between the investigative and adjudicative functions? Hence, we have a commissioner and a tribunal within competition.
Of course, we need separation, but let's be very clear. The Liberals refuse to acknowledge that the bread price fixing scheme that happened ripped off Canadians to the tune of $5 billion. And the fines that were levied for one of the most egregious examples were slaps on the wrist for these large corporations. What I'm proposing is a guideline that would give a judge the ability to impose fines triple the benefit accrued, or 10% of the revenue of a company. These are serious sanctions and serious penalties. And I don't understand why the Liberals are unwilling to impose some guidelines to let judges know they need to go further and impose harsher penalties for harsh crimes. If companies are going to rip off Canadians, they need to know that they are going to then suffer serious sanctions as a result. That's what I'm proposing. Penalties that stop these corporations from ripping off Canadians.
Yeah, I mean, so again, we'll have to beg to differ because we have increased penalties.
Just not on
maybe you want to increase them more. But is there? My understanding is the way that the law works is that the higher the potential severity of the penalty, the more important it is to have that separation between the adjudicative and investigative functions. And so, if you agree to a tribunal, you're not here under your private members bill proposing to take out the tribunal within the competition reforms that you're proposing, right?
No, not at all. And I just want to be clear, while we were able to force the government to bring in changes to anti-competitive behavior, the government refused to bring in those changes to the collusion or conspiracy or the price fixing. And the price fixing is what I'm talking about with the bread price fixing. That scenario that we've got evidence of, it happened in 2018. The Liberals and, frankly, the Conservatives are unwilling to go after that price fixing. And that's what I'm proposing in this bill that is outstanding, that price fixing or that conspiracy or when corporations work together to rip off Canadians, that's where we need penalties that are severe. Those penalties are not in the current government legislations. That's what my bill would do, and that would significantly protect consumers.
But just to be clear, though, you recognize the benefits of having an administrative tribunal. Could you speak to those benefits?
Right. We have not suggested anywhere in my bill that we would change that structure. We're strictly
because you recognize the important function that it plays?
Right. There's separations in terms of those who investigate and those who adjudicate, and that's normal. What I'm focused on is making sure if a corporation rips off a Canadian, they suffer serious penalties. And that is not in existence right now when it comes to collusion or conspiracy or when large corporations work together like we saw in the bread price fixing. That's an unfinished business that I'm speaking to that my bill would address.
But you don't advocate for circumventing the principles of natural justice within that regime of having the separation of powers and having fairness and due process to be grounded in the system that we're
I don't think
offering.
I've suggested anywhere, nor is that anywhere in the bill.
Okay, great. It's just your member does that on privacy. So that's why I'm asking, is because on privacy, your member here is completely willing to gut the bill on privacy of a tribunal, which we've heard
privacy
testimony.
and competition are very different. What I'm speaking to is related to the competition.
Well, they're not that different, but I'll end there.
And it's a very different matter.
Thank you, Mr. Turnbull. Monsieur Garon, la parole est à vous pour 6 minutes.
Mr. Garon, you have the floor for 6 minutes. Thank you, Mr. Chairman. It's a pleasure to see you, Mr. Singh. Congratulations on tabling your bill. You've emphasized groceries. That's the issue of the year. Your bill would amend rules for competition for all industries. So allow me to talk to you of open banking, as my Conservative colleague did. Today, the banks are going to become manufacturers of financial products, and the interfaces on which clients will buy these products and use them are apps. So You need legislation, regulations to provide a framework for all this. Now, in the budget you supported, there was an intent to regulate open banking. And you're a cultured man. In Quebec, you know, we have Desjardins, the biggest financial institution that comes under the auspices of the government of Quebec. In the government's bill, there seems to be this intention to impose a framework and put the gun to the head of Desjardins and tell them either you join the federal framework or you're isolated. There's no coordination with the Quebec government to harmonize all this. What's your position? Would you support legislation on open banking that is not coordinated with the Quebec government for the biggest employer in Quebec, our biggest financial institution? Would you support that in its current form? Well, today I prepared for my bill concerning competition, especially the issues that are hitting Canadians hard today, groceries, how hard it is to buy food. So what I proposed are measures to protect consumers, have larger penalties. Mr. Singh, you're doing politics here. You understand the value of time. I don't want to be disrespectful, but open banking puts Quebec before a fait accompli. You're saying you didn't make up your mind. I respect people who take their time. Well, I was explaining that what I prepared today is meant to defend and promote my bill. So that's an issue that you've raised today. I'm prepared to think about it and consider what you've proposed. But today, I want to target the issue before us, that is measures to protect consumers against large corporations that exploit people. That means large supermarkets as well as large telecoms. And that's what I want to discuss. Those are the issues I want to discuss today. But I'm open to considering. Okay, well, we'll wait for what you have to say about this. Now, in your bill, there's an important proportion that's already been applied in legislation that's been adopted already, C-56, 59, etc. There is a portion that would add a lot of constraints to the authorities on competition. The Competition Bureau must look for gains in efficiency before authorizing a transaction, and the benefit to the consumer must be proven. You're adding a constraint on the structure of the market, the consequences of a merger. If it goes beyond 60% market share, between 30 and 60%, there'd be an investigation. What do you do for a case, let's say in a region where there's a natural monopoly? You have a grocery chain that has difficulties, and if it doesn't merge, it'll go bankrupt and people won't have a supermarket anymore. The rigidity of your bill means that people wouldn't be able to eat in certain regions. Did you think about that? I thought about the impact of a monopoly. If there's a situation where two companies merge, and that creates more than a 60% market share for one company, that hurts people. There's no issue about that. So how can we help small businesses, regional businesses? I think that's the solution, and we have to do that. But I'm rigid about the idea of preventing monopolies in such a situation if a company has more than 60% market share. That's a problem. We've already seen the impact of monopolies and oligopolies. Mr. Singh, that hurts people. Why not 50%? Why not 55%? Why not 42% for that matter? Where does this 60% figure come from? Well, 60%, if everyone looks at the options in the market, it's to prevent a situation where large grocery chains such as Loblaws, Metro, Sobeys, Walmart, Costco, that's now the majority of supermarkets across the country. That's a problem. So to prevent that kind of situation, we consulted other jurisdictions worldwide, and this figure of 60% was clearly a limit that we must not exceed. We must not accept a situation where a company, what jurisdiction uses this 60% rigidly? If two companies merge and they have 60.1%. I'm not saying I'm against your bill. I'm trying to understand it. You don't analyze the issue. You just forbid this without looking at the consequences. Can you name 3 jurisdictions that do that? You consulted them all? Yes, we consulted things for the amendments. We looked at bills where in Europe and Australia, the legislation there guided our decision. What about the Americans? Do they have 60%? No, I don't think so. But the Americans have legislation on competition that are stronger than ours, but are more flexible. Well, we looked at that, but with this question of 60%, we really looked at examples in Europe and Australia. Thank you, Mr. Singh. Thank you, Mr. Massey.
It's a pleasure to be here. Thank you, Mr. Singh, for coming. I find it curious my Conservative colleagues have forgotten their own history. I remember the days of the Conservatives under it's Peter MacKay, then the David Orchard, the takeover, and so forth, and then even under Harper administration, where they just didn't put enough members in the House of Commons to oppose or to turn over a government because they didn't have them in there. They went to the lobby like they did the other time, just this past session, instead of actually taking on and trying to be constructive. So I think this bill is important because despite the differences at the table about things, we can always find reasons not to do it. This committee, though, however, has actually a good record of bipartisanship and actually putting on record some of these issues. The grocery store chains, in particular, was this committee that first brought the CEOs here because not only were they doing the bread price fixing, but they were also ending Pandemic Day the very same day across the board. So could you elaborate a little bit more about the issue over the bread pricing issue, because it is a basic staple of human life that we use in Canada, and then how potentially this bill would also affect the Rogers-Shaw merger that went ahead. Had we had this protection, what would have been the potential outcome for that?
Sure. Thank you very much for the question. So again, fundamentally, I can't think of something that's more important for Canadians than being able to buy food. It's a necessity, and everyone needs to do it. And what we're seeing very clearly, if we look across the country, when Canadians go to buy their groceries, they're getting ripped off when they go to check out. And they know it. When Canadians were asked this question, they said very clearly they felt that corporate greed was a major reason why the food prices were up. So this bill directly targets that. We're going to directly target the large corporate grocery stores in our country. That's the Loblaws, the Metro, the Sobeys, the Walmart, the Costco's. Go after them directly to say you cannot rip off consumers. And so this bill would provide additional protection. The specific area that's missing, and then I pointed out to the Liberals, is that while we were able to get them to change the penalties on anti-competitive behavior, they've refused to put in the strengthened penalties on conspiracy or when large corporations work together to rip off Canadians. So the bread price fixing scenario, which I've alluded to, was the large corporate grocery stores and large corporate bread producers got together and jacked up the price of bread. They were found guilty of doing so. And as a result, they received fines. The heftiest fine was on Canada Bread Company. It was only $50 million. In the context of how much they made, how much they ripped off Canadians, it was a slap on the wrist. Our bill provides clear guidelines for judges to impose stricter and more severe penalties. We know that in Canada, as a common law country, that the penalties will follow jurisprudence. And right now, the precedent that's been set is $50 million as the highest fine. That is simply not high enough. And so what we've provided is a guideline for a judge that they can go as high as this. And what we've provided are two of them, I think, are very significant. 10% of the revenue of a company. So the company like Loblaws that makes $60 billion, the fine can be as high as $6 billion. Giving a judge a clear guideline of how high they can go will allow us to have more severe penalties to deter these companies. Another example of what we've allowed for is triple the benefit accrued. So if collectively these corporations made $15 billion, then collectively a judge can impose a sanction of $15 billion in fines. That, again, is very, very serious deterrence. If a company knows that they're going to have a jeopardy of billions of dollars in fines, they're not going to rip off Canadians. So that's important. You mentioned also the Rogers-Shaw merger. And to be very clear, the Competition Bureau tried to stop it. We asked the minister directly to stop it, but the Liberals refused to stop this merger, and they should have. That merger is bad for Canadians. It's going to be bad for competition. It's going to lower options and choices, and it's going to increase prices. Our bill, which we were able to force the government to include some of those measures, would ensure that if a merger results in more than 30% of the market share, that there would be a very difficult process the company would have to go through to prove that it would benefit Canadians or prove that it can benefit consumers. That's a very difficult threshold, and they would not have been able to make that threshold proven in the case of the Rogers Shaw merger. In the case of a merger, in that case, it was almost 60%, but didn't hit that threshold. But if it was 60% or higher, then it would trigger an immediate ban of that merger, which is something we need to have. We need to have strict measures in place to prevent these oligopolies from being formed, because we're seeing the result of them. With corporate grocery stores, with telecommunications, Canadians have less choices, higher costs, and it is ripping them off.
Thank you. I know that the Liberals think that, some gotcha moment, because we, on the opposition side here, have been pushing against the tribunal on the privacy legislation, offering solutions for it. And one of the issues that we have with that is the mere fact that the Competition Bureau Tribunal is actually suing our Competition Bureau itself, and it's going to cost Canadian money and also confidence in the Competition Bureau, in my opinion. That's one of the reasons that we don't find a tribunal to be one of the best things in the place. Your bill looks to amend the tribunal, though, to some degree, by actually stopping it from being able to sue back to the Competition Bureau. Can you elaborate on that? Because it's absolutely absurd that we would actually have a position of the Competition Bureau basically not only just overturned, overruled, but then punished, and punishing Canadians because they stood up for the right things and they did the right professional job.
Yeah, I think that amendment just speaks for itself. The fact that it would prevent that type of lawsuit from happening would seem to be a very sensible, very sensible thing to do. If people want to exercise their right to raise a concern, that should not result in them being punished in return. So that, I think, is an appropriate amendment that we're pushing for, and it's something that I support.
When that can go ahead. Do I have time?
You're out of time, Mr. Massé.
Okay.
But we'll get back to you. Monsieur Perkins, the floor is yours for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Singh, for being here. You spoke a lot in your opening, obviously, about food prices. It's the main driver of this initiative. But after 9 years, the NDP has voted for every single budget that Justin Trudeau has put forward. And Canadians are more miserable and hungry than ever. Just as an example, lettuce is up 94% in that time, onions 69%, cabbage 70% since your deal with the Liberals. And a Dalhousie study, the food professor as he calls himself, shows that carbon taxes are increasing wholesale food prices by 34%. So my question is simple. Will you finally admit that carbon taxes increase the price of food?
Well, a couple of things are just false in that comment. 9 years, we have not supported every budget. That's not true. And in terms of the cost that Canadians are going through, Canadians were asked this very same question. Canadians were asked, what do you think is a major driver of your groceries? And Canadians were asked, and they answered, they said, the major driver that's pushing up the cost of their food is corporate greed. And then we also had an investigation. We had the Competition Bureau look into this. And it is very clear that corporations are ripping off Canadians. In fact, economists have made it clear that more and more large corporations are ripping off Canadians. So we're going after the major driver.
Increasing the price of food, yes or no?
We know the major driver, which is pushing up the price of food, is corporate greed. So why would we, and I don't know why the Conservatives are ignoring the major driver and looking at other things. We have something glaring in front of us that's hurting Canadians. The massive profits being accrued by CEOs of these large corporations, and the Conservatives want to ignore that, the major driver of the high cost of food, and want Canadians to believe that they actually care.
Mr. Singh, you're ignoring my question on the
Well, you're ignoring the major driver that is putting up the cost of food in our country.
Mr. Singh, you put a lot of fog in your support for the carbon tax recently at the Broadbent Institute. Do you support the carbon tax, yes or no?
Well, it's very interesting to me that we're talking about food prices, and I've made the assertion that corporate greed is driving up the cost of food, and Canadians agree with this assertion. And the member doesn't want to talk about corporate greed. The substance of this bill,
food prices, and
the substance of this bill is to take on corporate greed.
Will you answer a question, or are you just taking PMO talking points again? Does the carbon tax push up the price of food, and do you support the carbon tax? Yes or no?
The major driver pushing up the cost of food is corporate greed. And
Major
I don't know why the
major
member doesn't want to
driver
talk
is this
about
government's
corporate
policies
greed
that you
that is
support.
ripping off Canadians. When Canadians go in the grocery store and they're
many-
paying more money than ever for their groceries, they know they're getting ripped off.
How many people
I don't
are
know
now
why the
going
member
to
doesn't
the
want to
food
talk about
banks?
corporate greed.
How many people are now going to the food banks as a result of your support of this Liberal government?
As a result of subsequent Conservative and Liberal governments that have not taken on corporate greed, have ignored CEOs ripping off Canadians, right now 1 in 4 Canadian is skipping meals. There's record food bank usage because Liberals and
Thanks to your
Conservatives
support of Liberal
refuse to go
policies.
after corporate greed.
When you visited striking Metro workers and went on their picket line, did you inform them that your brother and NDP spokesman both lobby for Metro?
First of all, that's patently false. And secondly, the member knows very well that we have opposed corporate greed when it comes to Metro, Sobeys, Loblaws, Walmart, Costco. But it's interesting to me that Conservatives will attack everybody, including my family, rather than attack the CEOs that are ripping off Canadians.
We're just
That is very
attacking your
telling.
we're just
That is very
attacking your
telling
hypocrisy.
of who the
So did you
Conservatives
clear-
are.
when you
While I'm
attacked
directly
Loblaws-
going after the CEOs
you
of
attacked
corporations.
Loblaws-
Colleagues, Mr. Perkins, I'd appreciate if you could stay respectful in the words that you choose at this committee. I'll let you pursue.
He could avoid it if he answered the questions rather than avoiding them like the Liberals do. So
Not at all, sir. You know that I directly addressed the matter, which is that corporate greed is driving up food, and I'm attacking all large corporate grocery
Mr.
stores.
Chair, would you tell him
and
to stop talking over
maybe
me? I get
the
to ask
member doesn't want to
questions.
do that because his leader receives maximum donations from the CEO of Metro.
Point of order,
I'm
Mr.
willing to
Chair.
attack the CEOs of all corporations.
Mr. Singh, yes, Mr. Perkins.
The NDP leader is talking over my questions. He's a witness. He doesn't get to pose the questions, and he's harming the translation issues while he talks over me as I ask questions.
From my standpoint, it's been going both ways, but I would appreciate that, and you are both skilled parliamentarians. The practice is usually that the answer should be about as long as the question. And the questions have been fairly long, Mr. Perkins.
they've been about 20
So
seconds.
please just
They've been about
try to
20
keep that in mind going forward for all members. But Mr. Perkins, the floor is yours.
So when you began the crusade on the grocery stores, did you clear with the ethics commissioner your stand because of your brother's conflict before you chose to attack all the other grocers except the one that he works for?
First of all, that's patently false, and the member knows it. I've attacked every CEO that's ripping off Canadians, including Metro, including Sobeys, including Loblaws. The member knows that. The member's lies will not change the fact that I'm right now talking about taking on corporate greed, where the Conservatives want to talk about everything but try to attack family members rather than attacking the corporate greed of these large corporations.
You've gone after Loblaw over 70 times and hardly ever mentioned the word Metro until we just asked you. So are you denying or saying that you did not clear your attack on the grocers and your direct conflict with your brother's work with the ethics commissioner? You didn't bother to do that?
The member knows that I have attacked all corporate greed by name, specifically including
Except for
the
your brother.
CEO of Loblaws, the CEO
Did you
of
ever
Metro,
meet with the
CEO
did your brother ever
of,
meet with the CEO
of Sobeys,
of Metro?
the CEO. I've attacked Walmart, Costco.
Your
But the
answers along with my
Conservatives, though,
question. Did
Thank
you-
are
you,
did your
unwilling
brother
to
ever
go after
you.
corporate
Thank
greed.
you,
It's
Mr.
very
Metro.
telling that
Mr.
they're unwilling to
Perkins,
go
Mr.
after
Singh,
corporate greed.
That's enough. We're out of time. I'll now turn it over to MP Badaway for 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. Singh, for being here today. I'm not going to attempt to put the focus on the politics of the life that we live here in Ottawa, nor the parties that we represent. What I want to put the focus on is people and fairness. When the government introduced C-56 and C-59, that's in fact what we did, is we put the emphasis on, with respect to competition reform, on people and on fairness. And I think to some extent that's what you're trying to do here too, and I appreciate that. So with that said, we've established through those bills strengthening market studies and power to compel. We've clamped down on anti-competitive behavior and cross-industry collaboration. We've removed the efficiencies defense, strengthened the right to repair, strengthened anti-greenwashing provisions, strengthened merger review, and cracked down on unfair pricing practices, including drip pricing, as well as strengthening monetary penalties. I've read your PMB, and I appreciate the intent, but also appreciate what we've accomplished through 56 and 59. So what I really want to do is get a bit more granular, Mr. Singh, and drill down on the business part of it, not the politics part of it. So you mentioned some of the missing elements of those bills, and correct me if I'm wrong. That was missing. It was missing strengthened penalties. So my first question is, what more strengthened penalties do you want to have with respect to over and above, which is identified in both those bills? And the second point, that certain mergers should be banned if they reach a certain level. So if we can get a bit more granular on that, because quite frankly, my intent is what can we take away from this discussion and accomplish what we, the committee, I would only assume all of us, want to accomplish with respect to being fair and again, attaching it to the people that we represent.
Thank you, and I think it's important reflection just to bring it back. Who is this bill about? This bill is about people. It's about people that are going to the grocery store and getting ripped off. It's about people that are seeing their highest cell phone bills and internet fees that they're paying amongst the highest in the world, and knowing that Canadians need some relief. This bill is about protecting people, protecting consumers, and putting in stiffer penalties. And while I agree we've been able to push for amendments that have addressed a number of changes, including the ability for the Competition Bureau to investigate examples of anti-competitive behavior, including stiffer penalties when there is anti-competitive behavior. The piece that's missing is a piece that I spoke about, is when we look at one of the most glaring examples of large corporations ripping off Canadians, it's when they colluded or worked together to jack up the price of bread. That is termed price fixing. It could also be referred to as a conspiracy. It's also referred to as collusion. That behavior, when large corporations work together to rip off Canadians, that specific area was not addressed by the Liberals. And it's something that we had pushed for changes. Those changes were not accepted. So what we've included in my bill is to address the specific matter that I pointed out, that in one of the most egregious examples of bread price fixing, or most egregious examples of collusion, bread price fixing, the highest penalty that was given was $50 million to Canada Bread Company. $50 million is barely a slap on the wrist for that corporation, given the total amount of revenue that both of those, or all partners in that collusion, were able to accrue. The amount that they ripped off Canadians was tallied as $5 billion. So what my bill does is provide guidelines to a judge that in the case as severe as that, here are some areas where you can go. You can go to 10% of the revenue of a company. You can go to triple the benefit they accrued. That is severe deterrence. That is severe penalties that would deter these companies from ripping off people. So that's the specific measure. And the other measure that I've included is in the case where a merger would result in 60% or more of a market share, in that case, it should be immediately banned.
Thank you, Mr. Singh. Now, again, I mentioned what 56 and 59 contained. You mentioned those 2 points. Are there any other missing elements of those 2 bills?
The third area that's missing is strengthening penalties for agreements or arrangements between federal financial institutions to a fine of $25 million to match the existing provisions where it applies to criminal cartel penalties. This is, again, another way of capturing the idea of collusion or working together. These are arrangements where large corporations cooperate to rip off Canadians. And so to make the fine in line with what we would impose on a criminal cartel, we're saying it should be a crime to rip off Canadians. And if there's a crime, corporations should pay the fine. And that's what this bill is really about, making sure companies are not ripping off Canadians, making sure CEO greed doesn't take precedence over Canadians' need. And that's what we're doing in this bill.
Thank you. Thank you.
Merci beaucoup, Monsieur Baraway. La parole.
Thank you, Mr. Billaway. Now, Mr. Garon for 2.5 minutes. Thank you very much. Technical question for you, Mr. Singh. Can you name one unregulated market in Canada where there's one company that has more than 60% of the market share? The merger of Rogers and Shaw was almost at that level. With the merger of Rogers and Shaw, we were almost there, but it wasn't exactly that. Well, could you cite one merger in Canada with an over 60% market share that could have been prevented? This is a measure to prevent this in the future. It's something that's never happened then. Well, we're in a situation that's unprecedented right now. There are only 3 telecoms that have the majority of the market share. If there's another merger, of any of those telecoms, that will create a market share of over 60%. That's a problem. Well, I understand it going from 35 to 30, but 60, I'm giving you my opinion here at first glance. That's probably an aspect of the legislation that will never have teeth. I have one last question for you. I don't have much time, as you know. You know what it's like not to be official opposition. Glentel, Bell and Rogers have a co-company which will have a monopoly for cellular plans in Loblaws, supermarkets. You attack this structure, but even after C-56 and 59, there seems to be behavior that's anti-competitive that is still allowed. What's your opinion on this business model? Having a corporation, having both feet in a big supermarket and having a monopoly. Do you think this is anti-competitive? And do you think we should even go even further than what C-66 and 59 have already accomplished? Directly, yes. I put that question, and what would you do? I put that question to the Prime Minister. I said, that's a problem. The Liberal government must not let the situation continue. That is an issue that we never predicted. But what happened is there's an alliance now between a large corporation, the biggest supermarket chain, and a large telecom. Exactly what you've said. There will be another monopoly in supermarkets for telecommunication services. That's completely the wrong thing to do. And we need action on the part of the government immediately to stop this. That merits a bill to solve this problem of anti-competition before the election? Yes, I hope so. It's something that harms people, so I hope that we'll get measures to stop that. Thank you very much. Mr. Massey, you have the floor.
Actually, I'm glad this point's been raised because as New Democrats, we've been opposed to a number of these takeovers. A good review of some of the ones that took place, if we remember, is we actually had lost the Future Shop to Best Buy. We opposed that. We lost Zellers, that was taken over by Target, and then Target even abandoned Canada after Zellers actually had a union, actually had above wages and benefits for their workers, and were blown out of the Canadian market altogether because of that. We opposed. Another one, which is important for Quebec, was the Rona takeover by Lowe's, which we opposed. And the market share that you mentioned, 60%, is actually getting ahead things, and I appreciate that because when you look what's left over in the market, we've got TELUS, Bell, Rogers, Videotron, and Cogeco. So you have those as the major pieces that are left in the puzzle, and a 60% threshold is possible if we don't get in front. So perhaps you can elaborate about, yes, we can't predict the future, but we can send signals to the corporations that we just can't be treated like a colony anymore in terms of Canadian consumers.
It's a great example. I touched on it in the previous question, but it gives me a chance to elaborate on it. In terms of the 60% threshold, with not just in telecommunications, but also in grocery stores, with the massive amount of market share that each of these corporations now hold, if there's any additional mergers, we would see that 60% threshold being hit. And so what we're sending a message with this bill is that, no, that's not allowed. You cannot merge if it's in such a manner that's going to hurt Canadians. These mergers will be banned outright. So it would stop these companies from even considering those type of mergers. I think it's very important, sadly, given how concentrated things are at this point. As you mentioned in your question, Mr. Massey, that there are already such significant concentrations in the telecommunications market that any additional merger would easily hit that threshold, and we want to say that, no, that shouldn't happen. And I appreciate, Mr. Massey, you going through the history of all the mergers that New Democrats have opposed, and we can see clearly again and again, both Liberals and Conservatives have allowed these mergers to move forward, have had the opportunity to oppose them and have not, and that has done bad. That has been bad for Canadians. That has done injury to Canadians. And that's why I'm putting forward a bill right now that would actually stop this from happening.
And lastly, real quickly, it was mentioned about the European Union and Australia use as models because there are Commonwealth nations. And yes, the United States is close to us, but they also have antitrust laws. Do you want to touch on that, the advantage that they have of protecting their consumers than Canada does? Because we've, it can be from automotive to grocery store to a whole series of different things. We haven't been treated fairly.
Certainly. It's a really good point that Canadian laws around competition are amongst the weakest in the world. That's one of the things that we realized when we started digging deeper. And the Competition Bureau has been raising this concern for a long time, that they don't have the tools and the ability to go after abusive behavior. And in the States, with the antitrust laws, with their competition laws, they have much better protection for consumers. We need to do a lot more to ensure consumers aren't getting ripped off by large corporations.
Merci, Monsieur Singh. Monsieur Williams, la parole est à vous.
Mr. Singh, I want to go back to the cell phone question. After Rogers Shaw, I asked you, did you know how much Rogers, the prices went up and how much the wireless revenue per customer went up, and I didn't get an answer. It's 1% for the year, on already the highest prices at a time when this government promised that it would reduce prices by 50%. Actually, it said it did that. At the end of the day, we're seeing a government that's promising something, it's not delivering. We're seeing that you're standing behind them and not doing enough to force them. You have the power, sir. And even when you were in committee with Heritage last week, you had the Bell CEO, Mike Bibick, in front of you. You didn't even ask him a question about the new Loblaws rates and the no price and the no name rates that are being offered through Bell. What is your red line, sir, in order to hold this government up to stop mergers that are hurting Canadians? Like you say, not just bills or asking a question in Parliament, but your red line to hold this government up to ensure you're standing up for Canadians, because we've not seen that at all.
I'm glad you brought up the Bell CEO. I think it'd be important to note that I was the only leader that went up against CEOs. I've gone against the Bell CEO. I've taken on the grocery CEOs. Again, I was the only leader there to take on these wealthy and powerful corporations that are ripping off Canadians. I'm proud to be the only leader. I wish other leaders would understand how important this is and how much they're abusing Canadians, and they expect the leaders to show up. I believe that's a role of government, to stop big corporations from ripping off Canadians. That's why I showed up to ask these questions. That's why I will continue to take on big corporations.
You've allowed these corporations to roll over you.
And Canadians see right through you. Mr. Conservatives know that I'm fighting back against. I'm just going to finish my answer. The question was quite long. I'm going to finish my answer, and then I'm happy to take any more questions. It is clear, and the Liberal and the Conservative know this very well, that I've taken on corporate wealth and corporate greed and the exploitation of these CEOs. The question specifically around Bell, the matter had not arisen. I would have loved to ask that question to the Bell CEO. I asked the question to the Prime Minister when I learned of it, but it would have been a great question to put to the CEO. But let's point out, neither Pierre Poilievre or Justin Trudeau asked any questions of these CEOs, but I did.
Okay, thank you, Mr. Singh. Mr. Perkins.
I want to go back to MP Singh. I want to go back to my question. Did your brother meet with the CEO of Metro, yes or no?
Can you repeat the question?
Did your brother, who works for one of the largest lobbyist firms in Canada, meet with the CEO of Metro?
You know, it's really interesting. Again, the Conservatives want to attack my family, but not the corporate greed of the CEO of Metro, Loblaws, and Sobeys. I wonder why.
Well, on April 1st, 2025, the Prime Minister is going to increase the carbon tax again, which is jacking up the cost of everything, including food, which you seem to be concerned about, but unwilling to do anything about, other than a puffery bill here. So on April 1st, 2025, when the carbon tax increases again, will you oppose that carbon tax increase, yes or no?
I think it's very telling that the Conservative member just said that a bill that goes after the bread price fixing, that goes after collusion, that goes after large corporations ripping off Canadians, his quote is, he called that a, quote, puffery bill. That is very insightful into the Conservatives' viewpoint of corporate greed.
So the answer is no.
They think that stopping corporate greed, I want Canadians to know this. I'm going to answer, I'm going to finish the question. I'm going to respond to your question. I'm going to finish it.
Longer than I asked.
Not at all. They specifically are referring to a bill that's going to take on corporate greed and stop what happened with the bread price fixing. He's referring to that as a puffery bill. That shows you where the Conservatives stand on this.
I want to go back to the ethics issue. Did you, yes or no, talk to the ethics commissioner or the conflict of interest commissioner before you went out against the grocery companies to inform them and get clearance because of your brother's role in defending and lobbying for Metro? Did you do that, yes or no?
First of all, that's patently.
Are you breaking the ethics laws?
Firstly, that's patently false. And secondly, I've attacked the Loblaw CEO, the CEO of Metro, the CEO of Sobeys. I've directly called them out for ripping off Canadians. I've not heard the Conservatives do that. And I
So-
wonder why.
so you
I
haven't
believe
gone
the
to the
reason
ethics
is the Conservatives have no
commissioner. That's
interest
what you're saying.
in going after the real reason why Canadians are paying the highest prices for groceries, which is corporate
It's
greed.
because of the
They're going to
carbon
ignore
tax
that
and the
and know
budget
what they're
that
willing to
you
do. They're
continue
going to
to
attack
support
anyone
the
else
inflationary
but for the real
spending
reason.
that you
Mr.
continue
Perkins,
to
Mr.
support.
Singh, it's impossible to hear. Je pense qu'on peut faire mieux.
We can do better, Mr. Perkins.
The floor is yours.
So it'd be nice to get a straight answer for you once. You sound just like a Liberal minister. Yes or no, did you talk to the ethics commissioner to deal with your obvious conflict of interest?
The thrust of your question is, who am I attacking? I'm attacking the CEO of Metros. I'm attacking the CEO of Loblaws.
That's not the
I'm
question.
attacking the CEO of Sobeys. But the Conservatives are wanting to attack everyone else, even my family,
No, I'm
rather
willing-
than go
I'm
after
willing to
corporate
go
greed.
after you for
That
your
is very
hypocrisy.
telling.
Your
That is
blatant
very telling.
Thank you,
hypocrisy.
colleagues. That's all the time we had. We'll now turn it over to MP Gahir for 5 minutes.
Great. Thank you, Chair, and thank you to Mr. Singh for appearing before the committee. So I wanted to cover the overlap between what the government has presented and this bill. So we obviously passed major competition reforms with Bill C-56. They empower regulators to hold the companies accountable, and it does stand up for Canadians. We give more power to the Competition Bureau to conduct more effective investigations. We make it easier to block mergers that are not in the best interest of Canadians, and taking action against collaborators that stifle competition and that reduce consumer choice. If there was a lacking in C-56, I think that was largely covered by C-59, where the amendments that were brought forward, there's a more modern and effective competition law, and among other things, they help prevent harmful mergers and anti-competitive collaborations, and they hold the large farmers accountable. Now, I wanted to talk about your testimony that you gave in response to Mr. Badaway's questioning. You talked about how perhaps what your bill brings is more focus on price fixing and on penalties. But then I look at C-19, which is from 2022, and in C-19, Part 5 of Division 15, it amends the Competition Act to enhance the Commission of Competition investigative powers. It criminalizes wage fixing and related agreements. It increases maximum fines and administrative monetary penalties. And it clarifies that incomplete price disclosures, it's a false or misleading representation. It expands the definition of anti-competitive conduct, and it allows private access to the competition tribunal to remedy an abuse of dominance and improve the effectiveness of the merger notification requirement and other provisions. So when I look at all these bills in collaboration, it largely seems like what Bill C-352 is bringing is already covered. What are your comments to that?
I would first point out that the changes that were in both C-56 and C-59 were amendments that were specifically brought in by the NDP to address higher penalties, to address the anti-competitive behavior, and those amendments were successful, and we're happy that we were able to push for those things. But what's missing is the same approach to anti-competitive behavior is not being mirrored by the approach to price fixing. It is not the same approach. Even when you cited Bill C-19, it doesn't have the same rigor when approaching anti-competitive behavior as when approaching price fixing. And specifically when I talk about price fixing, we're talking about the situation where corporations collude or work together or have a conspiracy to set prices higher together. And specifically what I'm referring to is the bread price fixing. That matter, the bread price fixing, has not been addressed. It is one of the most egregious recent examples of large corporations ripping off Canadians. And that specific matter has yet to be addressed. And what I'm calling for are clear penalties that address that matter. That is the area where we suggested amendments that the Liberals turned down. So the Liberals have not shown a willingness to go after what has been the most egregious recent example of corporations working together to rip off Canadians, which is when they colluded to rip off Canadians with the price of bread. That's what I'm going after, and that's not specifically been addressed. We are setting a guideline for penalties to address the matter that the $50 million fine, which was the highest fine on one of the most egregious cases, was far too low, was barely a slap on the wrist. The guidelines that we're providing would give judges serious remedies to put in place a penalty as severe as 10% of the revenue of the corporation, which in the case of a company like Loblaws would be $6 billion. That's what I'm talking about when I talk about remedies.
Great. So, look, I'm not a competition lawyer, but as far as I am have knowledge of this area, price fixing is a type of anti-competitive behavior. And we are both lawyers. I think from my read of these bills in collaboration, they largely do cover the same thing. There are some enhancements that 352 brings, but I think the government has really worked on this area and worked hard over the years, and these three bills speak to that. I wanted to move on. I wanted to ask about the efficiencies exemption. Your bill will repeal the efficiencies exemption, but then it places the efficiency and competition comparison as a factor that could be considered in the substantial lessening or prevention of competition test, right? And I think maybe an unintended consequence of this is that your bill would still allow anti-competitive mergers to withstand the challenge on the basis of efficiencies, but on a discretionary basis. Was that the intent behind your bill?
The intent was to get rid of a loophole that allowed for corporations to merge, even though it hurts Canadians. If there is an amendment that would further strengthen the bill to protect Canadians against abuses, I'm always open to hearing that. But as it stands, this is a matter that's not been addressed and needs to be addressed. But I do want to reiterate that while there are three bills, and while New Democrats have forced this government to bring in strong amendments that would strengthen protection, it still does not address the specific nature of a conspiracy or a collusion. That the anti-competitive behavior matters that are addressed do not directly address what happened with the bread price fixing. And that is what I'm trying to get at this bill, that the most egregious case, one of the things that Canadians can still recall, Canadians remember when the 2018 ruling found that these companies had colluded, had worked together to rip them off, then the penalties were so minor, were barely slaps on the wrist. That is something that has to be remedied. And so that's why this bill is very explicit and very clear in addressing price fixing, those collusion scenarios, those conspiracy scenarios where large corporations rip off Canadians.
Great, thank you.
Merci, Monsieur Gaillard. Merci, Monsieur Singh. Félicitations pour le...
Congratulations on your bill that is going to this crucial step. Colleagues, we have a second hour with witnesses that are going to talk about this bill, so we'll suspend briefly. This meeting is suspended.
OK, chers collègues, je vous demanderai.
All right, dear colleagues, I ask you to come back to the table so that we don't lose too much time.
Your seats. We're resuming the meeting. And before we go to the testimonies by witnesses on 352, you've received a copy of the budget for the study for 352 of $10,500. It was circulated. Do I have unanimous consent to adopt it? I do. Thank you very much. Alors, donc, merci de vous joindre à nous.
So thank you for joining us for this first meeting examining Bill 352, C-352. We have Mr. Pierre Larouche, law professor at the University of Montreal, Matthew Boswell, Commissioner of Competition, Anthony Durocher, Deputy Commissioner, Competition Promotion Branch, and from the Canadian Bar Association, Antonio Di Domenico, the Secretary, Competition Law and Foreign Investment Section.
And without further ado, I'll yield the floor to Professor Larouche for 5 minutes. The floor is yours.
Thank you, Mr. Chairman. Thank you for this invitation to appear before your committee. Let me introduce myself briefly. I'm a professor in innovation in law at the University of Montreal, Faculty of Law. I have 30 years' experience in competition and economic governance, in part in private practice, but especially as a law professor in Europe. I taught in Europe for 15 years. I also trained at the College of Europe, many public servants at the European Union, competition law at Midwestern in the United States. I've been at the University of Montreal for 7 years. I continue to work in this field, and I've resumed contact with Canadian law. So I'm pleased to discuss this issue with you today. I'd like to start with an academic note about all this. There are a lot of good intentions behind all the changes to the Competition Act, such as C-56, C-59, but Canadian law is different from other OECD countries for two reasons: the length and complexity of the legislation, and the institutional framework is deficient. So the consequence here is that Canadian law is weak, it's difficult to apply, and defendants, the companies, enjoy a clear advantage, and they generally manage to resist application of the law. So when you say that it's long and complex, we have to stop adding more details to the legislation and go back to the basic principles, have clear positions, and give more room to the Commissioner and the Competition Bureau to do its work. When it comes to the institutional framework, in Canada, the Bureau should have decision-making powers, as is done everywhere in Europe and in the US, partly. It's especially true in the UK. If you look at what happened in Canadian law, especially the merger of Rogers and Shaw, the tribunal should ask only an appeal or legal control on the basis of a Bureau decision. So when it comes to the two specific questions concerning you today with Bill C-352, these are the two questions that Mr. Singh mentioned earlier. The increase in penalties under Section 45. That's a good idea in and of itself, but once again, it reflects the complexity of the Canadian law that forces us to choose between 45 and 90. The fines should be higher under 45, but in penal law, it's difficult. A good level of penalty would be 10% of overall income. When you look at the European Commission practice and American practice, the penalties have to be about the profit of the corporation in order for it to hurt. It's usually 5 to 6% of revenue. Maximum of 10% is on the right track, but that means penalties that should go into the hundreds of millions quite easily. The second proposal market share, that's a reference point that is a little bit obsolete. It's better to have a good general test and allow the Bureau to do its work. Market shares, that can go both ways. There can be an exceptional case, a merger with high market share, where it would still be possible to prove that it's good for the consumer, but there are mergers with lower market shares that can be harmful for the consumer, especially when both partners are close competitors in the market. This is within the contemporary analysis of competition law, and you don't address that with market shares levels. That creates the illusion that the only problem is horizontal mergers, but there are vertical mergers that can also be problematic. So those were my introductory comments. Thank you for listening to me today. Thank you very much, Professor Larouche. I'll now go on to Mr. Boswell from the Competition Bureau.
Good afternoon, Mr. Chair. Thank you for the invitation to appear before you today. Mon nom est Matthew Boswell et je suis...
My name is Matthew Boswell. I am the Competition Commissioner. I'm accompanied by my colleague Anthony Durocher, Deputy Commissioner, Competition Promotion. We're pleased to be here today to discuss Bill C-352. Thanks to many different legislative texts, Canadian competition policy is having a generational update. We are grateful to members of this committee and other people who have insisted on the necessity to strengthen competition in the Canadian economy. As you undoubtedly know, most of the important parts of Bill C-352 have been integrated into previous and future legislation, that is, Bills C-19, C-56, and C-59. These amendments follow on a number of important recommendations by the Bureau and harmonize our competition framework with the best international practices.
Competition in the marketplace forces firms to offer products and services that better meet consumer needs. Competition in the marketplace for ideas leads to better public policies. In my view, the sponsors of Bill C-52 and other private members' bills introduced this session deserve credit for prompting substantial improvements to the Competition Act. These improvements include, among other things, a significant revamp of our abuse of dominance provisions, including stronger penalties, the addition of rebuttable structural presumptions in merger review and stronger remedies for anti-competitive mergers, the possibility for formal market studies to be initiated by the Commissioner, and insulating the Commissioner of Competition from adverse cost awards at the Competition Tribunal. By my count, there are only a few outstanding elements of Bill C-352 that have not been taken forward already in other legislation. In the grand scheme of competition law modernization that has taken place, the remaining issues are not of pressing concern, but certainly some of them could further enhance the Competition Act. We would be happy to discuss those few elements. There are also some aspects of the bill that would, in my view, represent a step backwards, given prior reforms, such as the reintroduction of a cap on cartel fines. We would be happy, of course, to discuss these as well. During our time today, or perhaps in a future appearance before this committee, it might also be productive to discuss what I often refer to as the elephant in the room in Canada. That is, regulatory barriers to competition in this country. The Competition Act is a foundational tool to protect and promote greater competition in Canada, but it is not the only tool. To build on the incredible progress made in modernizing the Competition Act, all of us in the public sector, at all levels of government, need to examine what more can be done to address the regulations and policies that hold back competition in Canada, often unintentionally. We know that Canada's competitive intensity has decreased over the last 2 decades. It will take a whole-of-government approach to turn the tide, with the federal government working alongside municipal, provincial, and territorial governments. Increased competitiveness is key to tackling affordability challenges, improving consumer choice, and fostering stronger, more inclusive growth over the long term, and, importantly, addressing Canada's pressing need for more productivity. Competition policy in Canada is clearly having a moment. We need to seize that moment. There has never been a stronger consensus that Canada needs more competition. Now is the time for governments across Canada to work together to make competition a national economic priority. Permettez-moi de conclure en disant.
Allow me to conclude by saying that the Competition Bureau is determined to applying the law in a transparent manner based on principles and probative data. We have been steadfast in our efforts to implement new and improved tools that Parliament has granted us. We will remain faithful to that approach. Thank you for giving us the opportunity to appear before you today, and we'll be pleased to answer your questions.
Look forward to your questions.
Merci beaucoup, Monsieur Boswell.
Thank you, Mr. Boswell. Mr. DiDomenico now from the Canadian Bar Association, you have the floor.
I want to express appreciation on behalf of the CBA section for the invitation to appear today. Our members have significant experience advising a wide range of clients on competition matters, and we appreciate the opportunity to be heard, so thank you for that. By way of overview, many of the issues addressed in Bill C-352 have either been addressed in Bill C-56, which received royal assent in December of 2023, or are contained in Bill C-59, which is currently before the Senate. I would like to speak today regarding 2 proposals in Bill C-52, namely the merger prohibition and structural presumption provisions as Sections 8 and 9 of the bill, and the inclusion of efficiencies as a factor when assessing competitive effects for mergers and civil competitor collaborations at Sections 7 and 10 of the bill. Beginning with the merger prohibition provision, Bill C-52 would create an arbitrary bright line precluding Canada's Competition Bureau and the Competition Tribunal from evaluating the competitive effects of mergers with a combined market share of at or above 60%. The proposal would not take into account or differentiate between any level of increased concentration, even if the acquired target, for example, had a share of 1%. This would be an unprecedented and would make Canada a global outlier. Competition and antitrust laws globally recognize that market share and concentration alone are not themselves determinative of market power and competitive effects. As the Competition Act already recognizes, a conclusion regarding the competitive impact of a merger must evaluate important factors such as the likelihood of entry and expansion, the role played in the market by the acquired entity, the presence of other vigorous and effective competition in a market, and the nature of change and innovation in a market, among other things. In our submission, it would be inappropriate to fetter the ability of the Competition Bureau and the Competition Tribunal to conduct an analysis of market power and competitive effects based on the facts and evidence before them. Bill C-52's emphasis on market share and concentration to the exclusion of other factors also presents 3 further significant problems. First, the approach would remove entirely the analysis of what matters most, which is competitive conditions pre- and post-merger, in favor of a focus on just market share statistics that are not determinative themselves of market effects. Second, in many cases, a factual conclusion regarding market share cannot be reliably drawn based on a company's current market share. And third, merging parties frequently do not have the requisite data to determine what their market share is in any relevant antitrust market. Now, the Competition Bureau collects such information as part of its review, but unless the Bureau plans to share this information with merging parties or their counsel as part of the enforcement process, which they don't currently do unless required to in litigation, there are significant due process concerns that arise for merging parties. Turning to structural presumption provisions, the CBA section does not support the inclusion of structural presumptions in the Competition Act. We agree that concentration and market share levels can provide a useful preliminary screening mechanism to identify potentially problematic mergers. However, we disagree that a merger should be presumed to cause anti-competitive effects on the basis of market share alone. Further, including structural presumptions in the Competition Act, a statute, will not harmonize Canadian law with U.S. law. This is important. In the U.S., structural presumptions were introduced in non-statutory enforcement guidelines, which are flexible in nature and are preferable to a fixed statute. So it's not part of any U.S. legislation. So if structural presumptions are introduced, we would submit that the appropriate place to introduce them would be in the Competition Bureau's merger enforcement guidelines, which is similar to the approach that continues to be taken in the U.S. Finally, and turning now to efficiencies, Bill C-52 proposes the inclusion of efficiencies as an explicit statutory factor in Sections 93 and 90.1 subsection 2 of the Competition Act when assessing whether a merger or a civil competitor collaboration would likely substantially lessen or prevent competition. The CBA section agrees with this inclusion. It's well recognized in Canada and globally that efficiencies are a relevant factor when assessing competitive effects because they can result in mergers or competitor collaborations in being pro-competitive, enhancing productivity and benefiting consumers. The Competition Bureau has advocated for efficiencies to be among the list of factors that the Competition Tribunal can consider when assessing competitive effects, and this change would also reinforce the Bureau's current approach when assessing the competitive impact of mergers and civil competitor collaborations in any event. Thank you for the opportunity.
Merci beaucoup. Alors, pour commencer la discussion.
Thank you very much. I'll start the discussion by giving the floor to Mr. Viss for 6 minutes.
All the witnesses for being here today. I think no matter what part of the country you come from, Canadians in the context of this legislation are wondering, why the heck do I have to pay so much for groceries? I looked in great detail during the first hour of our meeting today. Canada needs more grocery competition report from the Competition Bureau, and two key points were sort of addressed that I almost find right now are going to be hard to achieve and may even find themselves contradictory. The report outlines, in addition to some other studies conducted by the Competition Bureau, that when the largest firms in an industry, when they consolidate their position, their market share, they are less likely to be replaced or face significant challenges to their market share. The report also notes that we need to encourage growth in the entry of new competitors. In the context of grocery stores, though, what I essentially read this morning was that the Competition Bureau outlines that it's going to be hard to see competition in our grocery store sector in Canada. Would that be a fair assumption, Mr. Boswell?
Thanks for the question. My colleague, Mr. Durocher, will answer this.
What our report outlined was steps that governments can take to increase competition in the grocery sector. So give a few examples of addressing restrictive covenants and property controls, which can keep out new entrants across the country. Another is to draw attention to the benefit of a foreign entrant coming into the Canadian marketplace as informed by others. But so we continue to work with governments to prioritize and to get movement on these. Right. The other is we have since launched an investigation into the use of property controls by the largest grocers as well. So there are steps that can be taken to protect and promote competition in the industry, and this is a priority sector for the Bureau.
Agreed. More broadly, though, would you agree with my assumption that it will be difficult to achieve greater competition given the concentration of the large firms right now?
Competition takes time to manifest itself, and certainly the sector is concentrated right now. But if a new entrant were to come in markets across the country, that would have an impact. But I think that there's no question it's a concentrated market. But that's why we're working with governments to take meaningful steps to try and make it more competitive.
Okay. would the Competition Bureau face the same types of challenges the federal government would face when seeking to encourage the municipal level of government to rezone property to allow for more grocery stores in our communities?
So in that regard, one of our key recommendations was for governments to limit and consider banning the use of property controls. That is within provincial and municipal remit. Yes. So it's not clear there's a role for the federal government. But if they violate competition laws by virtue of being anti-competitive in nature, then there is a role for them to be addressed through the Competition Act, which is federal legislation.
Thank you. It noted in this report that margins for our major grocery stores have increased 1% to 2%. I don't believe that's insignificant when you factor in the $1,000+ the average Canadian family is spending on a monthly basis at the grocery store. But would you agree that prices have also increased because of supply chain issues, carbon taxes, labor costs, and real estate as well?
So you're absolutely right. Our report stated that margins increased by 1% to 2%, which is modest but meaningful in the sense that it impacts and underscored the fact that we need more competition in the sector. We did not do a deep dive exploring all the ways that prices have gone up. There are a number of factors that came into place in the inflationary environment. There have been supply disruptions, but we did not do a deep dive on all the issues. We concentrated on examining competition because that's where our expertise lies.
Thank you. Has the Competition Bureau looked at food production in Canada as a key variable in the cost of food and the competition for products? I come from the part of Canada where we have the highest farm gate sales in the country, and that's largely due to the supply managed industries, but we're also the key producer of raspberries, blueberries, strawberries, and amongst other products that Canadians use. What impact does our current capacity to grow food have on what Canadians are paying at the grocery store?
So in our work, particularly in merger control, there are a number of cases where the Bureau has acted to protect competition, be it for to make sure that farmers are protected in terms of either the price they pay for fertilizer or their ability to sell grain. So there are a number of examples in that regard to make sure that the food supply chain is as competitive as it can be. Within the context of our market study, we did not do a granular.
Well, let's just touch base on that for a second, though. Supply chain. I also have the CN and CP rail lines go directly through my riding in the Fraser Canyon. Have we invested enough in critical infrastructure to allow for cheaper costs of goods through the flow of goods in Canada? Do we do a good enough job of allowing farmers to get their products to market in Canada?
So that is an area, if we look at rail competition, for example, we know that is critical for farmers and food producers to get their goods to market. And that is an area where it is a regulated space, and we've made recommendations in 2015 in the context of the Canada Transportation Act review for how to ensure that the rail system is as competitive as it can be.
Is it competitive enough?
You know, I think our mantra at the Competition Bureau is Canada needs more competition. I think we can point to a number of sectors where we need more competition in this country. And
so that would be a no?
Well, I can't opine on any specific.
Okay. One other point then with my limited time. The cost of labeling. I have a 1.5-year-old daughter, and the cost of formula at Costco was through the roof. It's a real expense for young mothers. And the number one thing, what we're being told at Costco, is that it's due to labeling issues. We face the same thing with children's Tylenol. What can we do to make labeling cheaper? How can we reduce red tape so mothers can get the formula they need quickly?
we're constantly advocating for ways to lessen barriers to entry and
What
expansion.
key recommendation can you provide?
Monsieur Vice, c'est tout le temps que vous aviez, malheureusement.
Mr. Viss, that's all the time you have. Thank you, Mr. Durocher.
Thank you, Chair. First, we have to recognize that Canada, by population, we are small at 40 million. Geographically, we are big, very big. Our south neighbor is big population, big economy, etc. So we are in some sort of a special situation when it comes to allowing or not allowing companies to scale up and serve Canadians across this vast country. Professor LaRouche, I'm glad to hear your comments on the large and complexity that is there. Complexity, the only people who get benefited from the complexity are the lawyers. And it just adds to the cost of administering the competition laws to the public sector and in dealing with these big companies. You also mentioned about the institutional framework. So are you suggesting that, we have got so many bills regarding this particular issue. Are you suggesting that maybe we should have a totally new bill starting from scratch? Not that it is possible, but I'm just saying.
Well, if you ask me as an academic, yes, I would redraft the bill from scratch and make it way simpler. I mean, if you look at, and I think the commissioner explained it very well, all the modifications that are on the table do some good, but they also make the law more complex and heavier. And, the context is the same everywhere. When the stakes in this litigation get in the 100 million or in the billion range in Europe, I've been in practice. It's very great. You have an open bar. You can bill as much as you want because everything will be challenged, you know, and every little piece of text will be taken apart. And I've seen it done everywhere. So to some extent, it's, I think the better approach for me is to keep the law general, let the authority do the job, and hammer the authority on the work it did. Make sure and spend time controlling that work.
I know, I agree with that approach, keeping the law, the legislation passed through Parliament as nimble as possible, delegating the authority for the regulation, and that can be flexible depending on the market needs or the changing circumstances. But, we are politicians. As political parties, we have to show to the people that we are working hard for you. Anyway, that is a different thing for a different time. And on the market share, again, I agree with you, keeping absolute number, 30%, 50%, 60%, without recognizing was the vertical merger or a lateral merger or the nature of the industry, nature of the sector, etc. So I agree. Is there anything that on the market share that other countries are doing best that we can adopt?
So what we see, well, first of all, I think earlier Mr. Singh mentioned 60% as a European figure. I don't think so. I think in Europe, the threshold for a firm to be found dominant is around 50%, in the US around 60%, but this is a different question than merger control. Now, what is now in C59, and again, we can argue whether it should be in C59 or in guidelines, but the HHI approach is in line with what is done in the US and in line with what is done in Europe. The figures, the thresholds are not quite the same, but it's typically a good way to get into a case.
Okay.
and spot the cases that deserve some closer attention and from those that you can just let go and focus your resources
Thank you.
elsewhere.
I know you have got ideas. If there are more ideas, you can give it in writing to the committee so that we can consider them when we prepare our report. Mr. Boswell, you did mention the regulations and the policies with different levels of the governments. I think if we work together as with one single approach, with some objective, it can benefit. Is there any example you'd like to give on that?
Oh, there are many examples. Let me just back up just to say that Canada has been dropping like a stone over the last several decades in terms of regulatory barriers to competition throughout our economy. The OECD does a report on what they call product market regulatory indicators. And the last report that came out in 2018, Canada was second last in OECD countries for regulatory barriers that hinder competition. They are everywhere. They are at all levels of government.
That you and I agree that there are problems. My thing is that if we can show an example how and what we can do, that can change it for better.
Absolutely. Interprovincial trade. If we were to eliminate the barriers to interprovincial trade in this country, we would immediately see a significant increase in our GDP, and most notably, it would benefit the poorest provinces the most. There's a great example. Foreign restrictions on investment also hinder competition in the country, and they are in many different sectors. And you can go down, and which is why we talk about all levels of government attacking this problem. And it is urgent that we need to attack this if we want our productivity to get back on track and remain a G7 country. You go down to the municipal level. There are restrictions on where food trucks can park relative to restaurants.
When it comes to interprovincial trade, we have signed free trade agreements with over 51 countries covering most of the things, but we don't have the free trade within Canada. But you talk to any federal politician, everybody would say that we have to work on free interprovincial trade, but nobody builds the cat.
Merci, M. Arya. That's all the time you had. M. Garon, la parole est à vous pour 6 minutes.
Mr. Garon, you have the floor for 6 minutes. Thank you, Mr. Chairman. First, I'd like to salute all these people for being with us today. I'd like to get back to Professor Larouche's testimony. We're examining bills here. C-56, C-59, there's always additions. It always seems virtuous, of course, but these are always marginal additions. From my understanding of your testimony, there are two ways to consider reform to the Competition Act. The first would be to have a very well-defined framework that gives a great deal of room to maneuver. And the other would be to add conditions, which would give the impression that we're acting, but that in the final analysis would make the legislation so complicated that it's inoperable. Recently, I was discussing the case of the U.S. with structural presumption. And what I was told is that in the U.S., for instance, there's a presumption in favor of the consumer, but in some cases, the competition authorities don't have to justify themselves as much as they do here in Canada. And that would add flexibility to the system. It would be faster, reduce appeals, because the interest of consumers are very diffuse, whereas those of corporations are very concentrated. They can afford a lot, so the consumer would be better protected. With that kind of regime, presumption in favor of the consumer be something that could be admitted into the Canadian competition system. Yes, it's something that could be admitted, but I want to be clear here. What you're talking about in these bills, and this one here before you, are reforms that are going in the right direction, but as you said, it's piecemeal. Let's take the example of the efficiency defense. It was put in there in 1980. This was something in the doctrine. We thought it was a good idea. It took 30, 40 years to get rid of it. In the meantime, everywhere else, this was something that was in the guidelines of the authorities. In the 90s, we added the idea that, yes, it's very nice to have better efficiency, but you have to prove that the consumers get something in the end. So how is this efficiency redistributed, in other words? Yes, in other jurisdictions, that was done with reinterpretation and authorities throughout the 90s. Here, we got stuck with a very rigid text and an interpretation that was very overwhelming in the Supreme Court. With all due respect to the Supreme Court, it was incomprehensible. They went into an even worse direction. Now it was abolished. I think we should allow the Competition Bureau to do whatever they want with those arguments. These are arguments that will come up all the time. They have to consider them. So is my interpretation correct? Because I'm no lawyer, but I have been around people in the economy and competition in the private sector. There are so many restraints and so many loopholes in the legislation that a business that can well afford to defend itself can always circumvent the law, whatever it is. So that's the first part of my question. And then there's that 60% rule. I asked Mr. Singh, where did he get that figure? He says, I looked at regimes across the world. We asked them which. He didn't know which. Now we realize there's not really a 60% rule. It's an arbitrary number. And we should be more consequential and say, what would be the effect of such and such a merger on consumer prices, for instance? How would efficiency be redistributed? So my impression is that we're adding constraints that could make the work of the regulator even more complex. Yes, I would tend to agree with you. The first question about the conduct of businesses, they do what they have to do. Given legislative texts, they will hire lawyers and consultants. More texts there are, the more arguments there are. When it's in the law, judges feel that they can interpret the law, and that gives us things like terre vita. But when it's Competition Bureau policies, judges tend to believe, well, we're going to be a little more discreet here and give the Bureau benefit of the doubt. So it's more favorable, I think, to have a balanced bill. On the 60%, the EU, the United States, when it comes to control of concentration, they start with HHI tests, indexes for concentration, as we will have with C59. Market shares don't play an enormous role because it's not a very good indicator. Because my understanding means that you can have two types of distribution of market share that give you the same index. So reducing that to market share prevents the Competition Bureau from doing its job because it reduces their tools to one tool only, that is this market share. Yes, the HHI takes into account not just the market share of the biggest, but the way all the other competitors are positioned in the market. Because if you have a concentration where you have one player who has 30%, but two others have 30% to counterbalance, it's not the same as you have one with 30%, and let's say you have another 200 that share the rest. So the HHI captures that. That's the tool that all authorities use. Thank you, Mr. Garon. Mr. Massé, you have the floor.
Mr. Chair, and thank you for the witnesses of being here. I noticed a tone difference from my Conservative colleagues. It must be early morning caffeine injection that they had from the previous witness. But I'm glad to have us talking about this issue in here and appreciate the fact that there has been some changes in the Competition Act over the years. Efficiencies one is, but I've been after for a long, long time. There's others. So we're here, and I think this context is important. And I'll ask this question across, maybe starting with Mr. Boswell across the board here. It is actually correct. This is a very difficult process to bring a private member's bill through. It is one of the tools that's available to ourselves as members of Parliament. And as well, too, we've seen recently the government did act on changing some legislation, not to the full extent. But here we are with some pros and cons to some of this bill here. But essentially what our options in front of us are right now is to either amend the bill in different aspects and carry on with the work where there's some good, strong consensus on items, or alternatively, quite frankly, with the time and the things that we're looking at, we're probably not going to see other types of changes in the Competition Act probably for another 2 to 3 years, quite frankly. I just don't see that happening. I mean, I can't predict the future, but given the fact that we have a Parliament that's winding down on the time frame right now, given the fact there would be another electoral call, given the fact that this committee would have to take this up again, and I'm pleased to hear the Competition Commissioner's comments about productivity and so forth and efficiencies related to regulatory issues, and that's probably a study we could even look at, but the chances of it getting to all those things is very, very reduced. So with all that in mind, I'll start with you, Commissioner. What do we do at this point? Do we look at amending the bill to give extra tools and strengthen for competition in Canada right now and work with what we got? Or do we wait the time frame that's going to be roughly and hope that, you know, at a bare minimum, we deal with this years later? Because that's really kind of where we're at now. We have the other private members bill that's in the Senate, which is great. We don't know what that's going to be, but these are the practical steps that are in front of us to choose, and those are the paths that we have available to us. And I do take the point again that it would be greater and a better process was there, but our democracy is one that may fail us in many respects. I still don't know a better process because the alternatives that other places in this world have are not better. So, Mr. Boswell, if you could go across to the witnesses, and please take the time you have. I think about 4 minutes to go, and 2 minutes per person, if you like.
Well, thank you for that very pragmatic question, and I was hoping to have an opportunity to address that head on, which is from the Competition Bureau's perspective. As I said in my opening comments, we're really pleased with the attention that's been paid to competition, that this private member's bill, other private members' bills, and government bills have done to amend the law. And I agree with Professor LaRouche. It was probably too complex out of the gates in 1986 when it was, some say drafted by the business community. In terms of this bill, I would, from the Competition Bureau perspective, say we don't need to address clauses 2, 3, 5, 6, 7, 8, 9, 10, and 11. Clause 4, which deals with the penalty provision for federal financial institutions, is great in terms of the 14 years, but it should be a fine in the discretion of the court, not a max fine, $25 million that it has now. Clause 12, the Bureau believes, and we put this in our recommendations to ISED, that a 3-year limitation period for notifiable transactions is a good step forward. Right now it's only 1 year. Our colleagues in the United States, there's no limitation period on reviewing mergers. And finally, with respect to the costs award, that has been addressed in C-59, but I just point out that in our submission to ISED, we talked about full immunization. C-59 is a pretty reasonable balance. So one way or the other, pretty happy with how that comes out, but really quite strongly don't believe we need those. We need those other clauses. They've been addressed in C-19, C-56, and hopefully soon in C-59, but this has been a valuable contribution to the debate in the marketplace of ideas.
Summary, just carry on our work, but looking at all the things that you've had there. So,
you could go ahead with a few sections, and the rest has been addressed adequately in other bills.
Okay, thank you. Thanks for that.
Yeah. So I mentioned earlier, I think many sections are kind of addressed already from those that were left and that were discussed earlier. I think the article section 3 is a good idea, but I would venture it's going to run into trouble before the courts. And the merger threshold sections 8 and 9 are, to me, not a good idea for reasons I explained earlier.
Thank you.
So the only thing I would note is, as you noted, the efficiencies defense has already been abolished. So with respect, and that is actually the current law of the land. The key, though, there's a bit of a lacuna in that in abolishing the efficiencies defense, efficiencies were not added as a factor that the Commissioner and the Competition Tribunal can consider in the context of a proposed merger or a civil competitor collaboration. I would characterize that as an oversight because globally, antitrust laws do see efficiencies as a factor that can be considered when assessing competitive effects. So as a result of that, efficiency should be built into sections 93 and 90.1 subsection 2 of the Competition Act.
And Commissioner, do you have opinion on that?
Respectfully, I don't agree with my friend, Mr. DiDomenico, who is a friend.
Yes.
I believe that it's been made very clear with the repeal of the efficiencies defense in the merger provisions and in the competitor collaborations. We still have a section that says any other factor that's relevant to competition. Minister Champagne has said that any other factor could be efficiencies that are pro-consumer. Okay. So we can look at it. We will look at it. We're not turning a blind eye to it. We do not need to reintroduce this complicated offsetting and outweigh test that existed in the old version. It's going to complicate things and stick us in the old version where there's a notion that if you have these efficiencies, but they, and the merger harms consumers, it could still go ahead. I'd say leave it out entirely. We will consider it under the any other factor provision that's in the Act.
Okay, so we can follow up on this as well, too. I guess the point that I'm trying to make here is that things moved on as the bill was crafted and created, and that's normal in terms of processes. And same with my position on the tribunal, going through Bill C-27. I've kept myself open to creating a tribunal, but part of it, but from the evidence that's been presented, and we have never really on this table dealt with tribunals before, I've come to some conclusions that have given me great concerns. So we left the door open for an amendment to the tribunal, not to get rid of it, but I mean, we could even get rid of the tribunal here if this actually body chose to do so. But at any rate, that's kind of where we're at. So we're in a work in progress environment here. So I hope we can actually kind of continue to add on while we have the opportunity.
Merci, Monsieur Massé. Monsieur Généreux.
Mr. Généreux, 5 minutes. Thank you, Mr. Chairman. Thank you to the witnesses. Mr. Boswell, you talked about a generational update. What do you mean at that when it comes to updating a bill? But before you answer that question, I'd like to ask you this. Earlier, Mr. Viss said the question that's killing us, if I could say so, is that a bill like this, will it really have an impact on the cost of groceries? That's the first question.
Merci pour.
Thank you for the question, Mr. Chairman. If Mr. Généreux agrees, I will answer in English, as it's quite technical.
So the combination of the bills that have come in front of this committee and the House Finance Committee and the Senate over the last several years will, I believe, have an impact in the long term on aspects of competition throughout our economy. It's not going to happen overnight. There's no doubt about that. And we're not, we don't want to be in the business of over-promising. But this country has been a country that has not paid attention to the importance of competition in the organization of its economic affairs for decades, literally decades. We're a country where we have multiple oligopolies, where we have, very significant competitive intensity problems. And this is one important piece to drive competition, which drives down prices, which increases consumer choice, drives innovation, drives productivity. Those are the important long-term benefits of having a country that places importance on competition. Can it, overnight fix the affordability crisis that we're experiencing? No, and we're not promising that. But these are important reforms that turn the ship around, a ship that's been sailing since at least 1986.
Alors, demain matin, un gouvernement fait un.
So tomorrow morning, let's say a government made a choice and decided to cut the carbon tax, because the people who produce the food we eat and we buy in the grocery stores are taxed at different levels, including the carbon tax now. The people who transport that food are also taxed. The people who process that food are taxed, including the carbon tax. So, of course, that carbon tax is passed on by supermarkets to the consumer. If a government was to remove the carbon tax tomorrow morning, would it have a direct effect on consumer prices?
Well, thank you for the question. I mean, generally speaking, as a matter of economics, if you remove costs in the supply chain, you're going to end up being able to, generally speaking, offer products at a lower price.
Donc, la réponse est oui.
So the answer is yes. You also mention productivity, the word productivity. To my knowledge, in Canada, 1 hour worked is about $55 in revenue for Canada. 1 hour in the U.S. is about $75, roughly, and in Europe about $80. What's our problem in Canada when it comes to productivity? What's the link between that productivity or lack of productivity and the bill before us?
Thank you for the question. I would say it goes beyond the bill before us today, C-352. It goes to the point that I was making, that competition drives productivity. There are innumerable studies that point to that very clearly. Competition drives productivity in an economy and is a key pillar of a capitalist economy for that very point. And as I say, we have not placed significant emphasis on competition in this country for decades. I mean, this was pointed out. There was a blue ribbon panel in 2008 the government put together to look at competition in the economy. And in that panel in 2008, they pointed out how competition has been neglected in Canada and how competition is a key driver of productivity. And we're at the point now where the senior deputy commissioner, senior deputy governor of the Bank of Canada a month ago said it's time to break the glass. There's an emergency. There's urgency. We need to address these. And she, in a speech, pointed clearly to competition as vital to address this productivity problem in our country.
Merci. J'aimerais laisser mon collègue.
Thank you. I'd like to allow a few seconds for Mr. Williams to put a question.
But a brief question.
Brief question. Thank you. And Commissioners, thank you for coming today. I know you're starting an airline industry study. The public submission deadline is June 17th. These are the new powers by C-56, so we're just testing those out. One concern we have is there's a letter written by the minister, the industry minister, who just said, his quote was, "We want you to focus on domestic airline services, not airports." Obviously, we think you should be looking at the whole thing. Airport competition is just as important as the domestic side. If that comes back, and does the minister, through 56, the powers we have, does it allow him to change the course of the study after we've reviewed it or after you've gotten the public consultation on the 17th, yes or no?
My understanding is that the changes to the law from C-56, we consult on the terms of reference, which we have out there now, as you rightly point out. And once we hear input from Canadians, and we're getting a lot of input, I can tell you that, we then may amend the terms of reference depending on points that people have made in our consultation. We then provide that to the minister for approval, the terms of reference of the study.
And can he change the study if he wishes?
Thank you, Mr. Williams, but that wasn't that short of a question you asked, et Monsieur Généreux m'a eu. Je pensais que c'était...
Mr. Généreux.
Mr. Généreux got me. I thought it was time for him. Now, we started at 12:08, if you agree. In order to be fair to everyone, I'll give the floor to someone else for 5 minutes.
C'est le tour de Monsieur Van Bynen. Merci, Monsieur le Président. J'ai appris beaucoup pendant cette conversation. Nous avons parlé des rapports du Bureau de la concurrence. Selon ce bureau, il faut moderniser les lois canadiennes sur la concurrence pour l'adapter à l'économie d'aujourd'hui. De nouveaux éléments ont été introduits. Les obstacles réglementaires sont un aspect important, surtout pour le commerce interprovincial. Y a-t-il d'autres éléments qui devraient être pris en considération? Des éléments pour améliorer l'intensité concurrentielle du Canada? Rappel au règlement, s'il vous plaît. Oh.
OK, il y a peut-être un petit enjeu technique. Est-ce que... If we try again, are you...
I'm sorry, it was me.
Now,
okay, I'm sorry. Go ahead, Mr. Boswell.
Well, I do think that this whole of government approach that I spoke of earlier is something that we as a nation should undertake with leadership from the federal government. And when I talk about that, and when we talk about that at the Bureau, it's not like we've created this out of thin air. This is what other countries have done and are doing. In the 1990s, the Australians had a productivity commission where they examined 1,800 laws and regulations, and with a view to enhancing competition throughout the Australian economy. The federal level, the Australian states also participated, and it resulted in a significant increase in their GDP. 2.5% Australian GDP went up as a result of that work. about 5,000 Australian dollars per household, which is a significant amount of money in the 90s. So there's the Australian example. The United States currently has a whole of government approach to competition in the American economy. There's a White House Competition Council where all the secretaries of the various departments in the U.S. government are tasked with identifying competition problems within their area of remit and fixing them. So we're not talking about something that hasn't been done elsewhere in the world, but it's something that we desperately need to get to work on in Canada if we want to solve these problems we have.
Thank you. That's good for us to hear about other examples that are happening outside of Canada, and that might be a good starting point for us to go forward with. We talked about, or we've heard about how the reference to the price on carbon was an issue in terms of the cost of food. And I heard earlier there was a statement about we would measure the effectiveness of competition and the value and how the value of these efficiency arguments were translated to value for the consumer. How could we accomplish that? If we're looking at efficiencies, how do we ensure that those efficiencies are realized by the consumer? Perhaps, Mr. LaRouche, if you could address that.
Well, in terms of legislative or text or guidelines, typically you add language to the efficiency defense to say that the party invoking the efficiency defense must show that the efficiencies flow through to the consumers, at least in a reasonable part. And then the authority has the tools to ask the question, well, okay, you're going to save 10% on your cost with this merger. How much of this is going to be passed through to the consumers? That's the type of provision that you need.
Any examples of that could be used as a reference point?
Yes, it's standard in EU legislation, and I believe it's in the guidelines in the U.S. as well.
I wonder if you could forward that on to us so that can be part of the record here as well. The other item that I was looking at was in terms of the clauses that you felt weren't as effective, and you referenced clause number 3, 8, and 9. Do we have all the details on that, your reasons around the need to change clauses 3, 8, and 9? Professor LaRouche?
Yeah, 8 and 9, I would think that what is now is in C59 with the HHI index is good. That's more in line with worldwide standards than market share thresholds, for sure. And as far as 3 is concerned, to me, the underlying problem is this need to always choose between 45 and 90.1 as a vehicle. That will not be changed. Then it's a good idea to put some serious sanctions under 3 as well. But it will run into problems before courts because these are criminal provisions. But if you want to have a level of sanction that matches what is done elsewhere, it should be around 10% as a theoretical maximum, and typically the authority will go around 4 or 5% of turnover, so at the level where the profits should be. That's the practice. And that would mean in Canada, if you go on a factor of 1 to 10 with the EU or the US, we would be playing in the 100 million range.
Merci, Monsieur Van Bynen. C'est tout le temps que vous...
Thank you, Mr. Van Bynen. Mr. Garon for 2.5 minutes. Thank you, Mr. Chairman. I didn't expect to discuss this, but since Mr. Williams started, I'll put this question to Mr. Boswell. There are 3 major airports in the Montreal area, Saint-Hubert, Dorval, and Mirabel. There's one at airport administration for 2 of them. The consequence is they just about closed one to public commercial flights. Seems to me that is designed by the federal government to be anti-competitive and to have anti-competitive behavior by airports of Montreal. Are these among the subjects that interest you now that you have more investigative powers?
I think that, thank you for the question, by the way, and apologize answering in English, but, We are going to be looking at a broad array of issues in this market study. We have the draft terms of reference out now and hope to have those finalized later in June or July. But, right now in the draft, we talk about looking at airport governance as it impacts competition. And we'll see if that becomes part of the final terms of reference.
Et, dans le secteur privé,
in the private sector, would it be tolerated if one company buys another and takes just about the entire market share and decides to shut it down to commercial activity? If we were any other field than aviation, would that kind of practice be tolerated?
Alors qu'on a des problèmes.
Whereas we have capacity problems.
It's difficult to speculate on hypotheticals on the fly, so I
Faites-vous plaisir.
refrain the temptation to give you an answer.
Merci beaucoup.
Thank you very much. A very quick question for Mr. Larouche. We have less than a minute left. You talked about the regulatory constraints that are constraints on competition. You've worked in Europe. It's recognized for having a major regulatory regime. What could we do to try to make things more flexible? Where should we start? That's a major question. You have 20 seconds to answer. I'd say 12 seconds. Well, I think that Commissioner Boswell is totally correct when he talks about the horizontal approach. There's a great deal of work to be done. The investigative procedure that will be put into place for the first time with aviation services in Canada should allow the Commissioner and the Competition Bureau to give specific recommendations about amendments. That is the horizontal approach. We could put our finger on problems that exist elsewhere. And beyond all that, there's a change in mentality. I've been back in the country for 7 years. It's pretty quiet in Canada. Markets are lazy, I'd say. And when you look at supermarkets, for instance, we talked about that today, margins are very high. If you say 5%, it's not much, but in reality, it's about 2% in the US, 1% in Europe. So 5% is very high. And the major players have identical policies. Everyone has very similar supermarkets. People complain prices are too high. They may broaden their range, Maxi, Super C, whatever. But in Europe, you have a greater range of business models. There are new entrants in the markets. You can be up there with the high market, or then you can have a lower middle price supermarket. Every supermarket has its own business model. We have to have a situation where businesses are afraid of what others will do rather than what we see today, where they anticipate what others will do very easily. Very interesting. Mr. Massey?
If you can use less than the full 2 minutes and a half.
I will, Mr. Chair, so I'll let our guests go as well. But I do want to make sure I get on the record about the 60%. This committee did deal with a situation that had a 60% threshold. It was Superior Propane. And Superior Propane used the efficiency defense and became basically an effect on rural communities in particular. So I don't want, in this committee, we would even have a recommendation or work on this in the past with regards to Superior Propane, as it was a significant issue that we dealt with in the study of this before. So thank you, Mr. Chair, and I'll let everybody get their extra 2 minutes now.
Thank you very much, Mr. Massey. Ça conclut notre discussion. Merci.
That concludes our discussion. We thank our witnesses. Meeting adjourned.